All right, good morning, K-Score. So, wanted to kick this off. The first ever audio experience when it comes to, prepping for the real estate exam. And today, I want to talk about the general principles of agency. And with that, guys, in the national exam, 13%, which would equate to about 10 to 11 questions, will be pertaining to this topic on the national exam. So this is going to go through agency versus non-agency relationships, the different types of agents there are, brokerage relationships, whether it's transactional broker, your facilitator. It's also going to go through fiduciary responsibilities, right? That cold AC, as well as POA, power of attorney, the creation of agency, property managers, fiduciary responsibilities. So as we're going through this, we want to make sure that we know that you can be one of three different types of agents. And what that looks like is there is a special agent, a general agent, and a universal agent. And when you start thinking about a special agent, I want you to think about what you're seeing as far as someone that's helping someone buy or sell 123 Main Street, right? We're going out with a specific and strategic plan in place to go help someone either buy a house or sell a house. That is a special agent. Then what we have is what's known as a general agent. This is someone that has multiple responsibilities. This is someone that has responsibilities that maybe they're going to help someone with collecting rent. They're going to go with tenant placement. This is what's known as a general agent, and I want you to think of a property manager. A property manager would be a general agent. They have more roles than just helping someone buy and sell 123 Main Street. And then your third type of agent for the purpose of the quiz will be your universal agent. This is someone that has POA. This is power of attorney. This might be someone that has hired a real estate agent and has said, hey, I am looking for an investment property. And as long as this investment property is under $400,000 and can net me $300 a month in revenue, I want you to put us under contract. So this agent can actually go out, look for these properties, and actually sign on behalf of their client as a power of attorney. So those are going to be the three different relationships as far as agency goes, as far as special agent, general agent, and universal agent. You'll need to know all three of those for the exam. So as far as working with the public, there's truly two different ways that we can do this. We can work with someone as a customer, right? They are our customer, and that means that we don't have any relationship with this person. This is someone that you can come into, interact with them in two different ways. You might be the agent for someone representing 123 Main Street and you're hosting an open house. And during this open house, someone walks in off the street. And when they walk in off the street, you're representing the seller. So you would treat that person that has come in to go check out your open house as a customer, which means that we do not have a fiduciary responsibility for this person. And that means that we cannot give them advice. We owe them three different things when they do come into our world, and we'll talk about that a little bit later. But what we don't owe them is that fiduciary responsibility, which we would owe for a principal or our client, which will be used interchangeably on the exam. So when I start thinking about a principal or client, this is someone that we represent. We put their interest above our own. This is someone that we have an agency relationship with. So on your exam, they're going to talk about principal and client, and these will be used interchangeably through the entire exam. As we look at the exam a little bit more, on the national piece only, and this is truly national, they're also going to have another type of agency called dual agency. Now, dual agency means this. It means that I represent both the seller and the buyer, and I have a fiduciary responsibility for both of them, which means that I am going to go make sure that the buyer wins and the seller wins. Now, on the national exam, this is perfectly legal as long as it's disclosed to both parties and both parties agree that you can represent them as an agent. So dual agency is, like I said, that situation where you represent both sides in a transaction, both the buyer and the seller. Now, if we're talking about the Colorado exam, I don't care what the other answers are. If you see a question around dual agency in Colorado, it's illegal. Because in Colorado, we believe this. We believe that there is no way that I can represent both parties and get the seller the most amount of money as possible and help the seller win while saving the buyer as much money as possible to help them win, right? There's a conflict of interest there. And so for the national exam, there's enough states to where they allow the buyer and the seller to be represented in dual agency. But we do not offer that with the rest of in the rest of Colorado because we don't know how we can serve both interests at the same time. What we do have in Colorado is this: transaction brokerage. So we can actually represent the contract, right? We represent the contract for both parties, the buyer and the seller. So when we're going through here, what the transaction brokerage relationship looks like is this. I'm a referee. I am presenting paperwork. And so what this looks like is I would have agency relationship with both the buyer and the seller at one point. And I have 123 Main Street on the market for sale, and I have another buyer that I'm already representing under agency. And my buyer that I'm representing says, hey, Charles, I see that you have a listing, 123 Main Street, and I would like to go look at it. I show my buyer that I have agency relationship for 123 Main Street, and they say, you know what, I want to write an offer. So awesome. What I need to do now is I need to consult with my buyer who I have agency with and my seller who I have agency with and see if I can drop down. I leave my agency relationship with both of these people and I drop down into a transaction broker relationship. So this is something where I'm actually dropping down into this piece to help them get to the finish line. I don't offer them any more advice. I am just the conduit to get the contract to the finish line. Zero fiduciary responsibility at this point. So what we also have to do is this, everyone. We always have to disclose, right? I just told you that I need to disclose if I'm going to be a dual agent on the national exam. I have to have disclosures when I'm dropping down to a transaction brokerage, as well as when I am working with a seller and a customer walks in, I also have to have an agency disclosure. This agency disclosure actually lets the confused buyer at this point, right, know who I'm actually representing. Because if we don't let the parties know who we're representing, they could think that we're representing them and we don't have their best interests. Remember, the person that we represent as an agent, we have that fiduciary responsibility to. So if someone walks in off the street, I have to help my seller win. So I must disclose to that customer who my allegiances are to with an agency disclosure. Keep in mind, guys, this agency disclosure is very, very important. And this is where a lot of agents get in trouble because someone thinks that they have their interest, right? The seller, the agent is actually representing them and they're not. So we must disclose with that agency disclosure how we can help that buyer and or seller. And this is also, guys, when we start thinking about this, there's a couple different ways that we can establish these agency relationships. One is expressed agency, right? Expressed agency looks like this. I either have an agency agreement in writing and or it's a verbal agreement, right? And it's like, hey, Mr. and Mrs. Buyer, I would like to represent you as your agent. And they're like, you know what, Charles, that sounds awesome. We would love to have you as our agent. That's expressed agency right then and there, right? Like there's no contract in place, but we have both verbally expressed that we want to work with one another. The other piece of this expressed agency would be in writing. Like there's an actual agency agreement that we have with one another, and that one would actually be the enforceable one. So all contracts must be in writing to be enforceable. The other one would be implied. An implied agency would look like this. I'm talking to someone, I'm saying, hey, I'm going to go look at houses this weekend. Do you want to go? And they jump in my car and we go look at houses, right? Through our actions, right? I'm driving to go look at houses. We're looking at houses together. That would be implied. That's an implied agency agreement, which is not enforceable, which is also where one of those issues pops up because they actually think that we have a fiduciary responsibility to them, and we don't, because the only way that agency can truly be established in Colorado is in writing because of the statute of frauds. So another type of interest that you will see on your exam will be an agency coupled with interest. And this is what I want you to think about. I want you to think about a listing that is on the market, and someone walks in and they say, hey Charles, I want you to sell me the house. And I'm like, well, what's your plan with this land? And they say, well, I'm actually going to build it. I'm going to build on this land. Well, an agency coupled with interest would be when I say, you know what, I'll sell this land to you as long as you use me to sell the house after you build on it. So this would be a tie-in arrangement with that coupled with interest piece. That's actually illegal, right? So there's two different pieces when we're going through this agency coupled with interest. And if it looks like that, that's a tie-in arrangement. And when you hear something on the exam where someone's actually saying, you know what, the interest in your property is because that you've actually made a deal to where you're going to be benefiting on numerous different angles, and I'll only do this if you do that, that would be illegal. That would be called a tie-in arrangement. The legal version of an agency coupled with interest would look like this. Maybe I am doing the fix and flip myself, and I'm the real estate agent. So I'm getting a percentage of the sale once I sell the property, right? I'm going to make some profit on my fix and flip, hopefully, and I'm getting a commission for selling my house as well. That's agency coupled with interest, which is legal. The other one is called a tie-in arrangement, which is illegal, and it's also an antitrust violation. Now, let's look at what agency law really looks like in a couple different pieces, and this is how I think you're going to see it on your exam. We have an in-writing agreement called an exclusive right to sell listing. So I am representing the seller in this case. What this would look like would be I'm representing 123 Main Street, and if any offers come in, I get paid if we get them to the closing table. On the exam, what this is going to say is which contract has the most protections for the agent. And it's this one. It's the exclusive right to sell listing, which means this. If the seller is standing out on their porch and the neighbor says, hey, I see that you're selling your house. I have a buddy that would actually like to live there. And the seller is actually the one that finds the buyer. You, the agent, still get paid. Because of the exclusive right, it has the most protections for you, the agent. The other agency agreement that you're going to see is called the exclusive agency agreement, which means this. The brokerage is the only one the only agent that is able to collect a commission. And if that same seller, again, is on their porch and that neighbor walks over and says, hey, I have someone that would like to buy your house, and the seller is the procuring cause, you do not get paid. They don't have to pay you, the real estate agent, because you were not the procuring cause. So on the exam, it's going to say something like, which one of these agency agreements must you be the procuring cause to get paid? Exclusive agency listing is going to be the answer for that one. Like, you actually have to be the one to find the buyer. You're also going to see something called an open listing, and this is what I want you to think about. I want you to think of this house with 7 different signs in the yard. And it could be 6, 7, 8, 9, however many signs you want to think about. And someone's driving down the street, and they call the 3rd sign. And they say, hey, I see 123 Main Street. It's on the market. I would like to buy it. That's the agent that gets paid. All right? Whatever agent's phone number rings, their phone rings, that's the agent that actually gets paid in this case. That's called an open listing. Numerous brokers are selling this house, and whichever agent's phone rings is the agent that will actually get paid. Now, the same thing with the exclusive agency listing. If the buyer actually goes and knocks on the seller's door, no agent gets paid. So there is also a procuring cause. It's either any brokerage and or the seller. You'll also see a net listing agreement. This one's going to be worded like this. Which one of these listing agreements is legal, but sometimes will have an agent act unethically, or could have an agent act unethically? This would be the net listing. What this looks like is this. You're talking to the sellers, and the sellers say, you know what, we just need to, net $50,000. And you're like, awesome. Let's list your house for $500,000. And after you pay me my commission, you would net that $50K. Well, the reason why this is an issue is because this. Maybe the agent, and I'm not saying any of you because I know that you're all going to be ethical, is that the agent knows that the house is actually worth $600,000. Well, they listed for $500,000. The seller is going to get their $50K, but the agent would actually make the additional $100,000 because anything above what the seller wanted to net, the agent would get. While this is legal for the national exam, this could have the agent act unethically, and so that's why it's frowned upon. So if you see a question on the exam around could have an agent act unethically, this is the answer, the net listing. Now, if we were to switch over to the buyer agency agreements, there's 3 that I want you to think about. We have the exclusive buyer agency agreement, and just like the exclusive right to sell, you do not need to be the procuring cause to get paid. This one has the most protections for you, the agent. Now, there's a second one, and this is how I want you to think of it. So you see the exclusive agency buyer agency agreement. The word agency is in there twice. When you see this agreement in and on your test, and it says agency twice, that's the one where you have to be the procuring cause. So let's say this, you have this agreement in place, your buyer, while you're on vacation or that you're doing other things, goes to a new build and looks at the new build, and the new build rep says, hey, you know what, do you have an agent? And they say, yeah, I have an agent. And they say, well, hey, if you sign with me, we'll take $15,000 off of this house. Well, because you were not the procuring cause and you were not with this buyer to go look at this house, they say, you know what, that actually sounds awesome. So what they do is they sign on the house. You do not get paid because you were not the procuring cause. You were not with your client when they went to go look. So this one, when you see agency twice, this one means you must be the procuring cause to get paid. And then there's the open buyer agency agreement. This thing all over again. I want you to think of this though. You, the agent, or you, the buyer goes out and pursues a bunch of different real estate agents. And I like to think of this person more as an investor. And when you guys all get your license, you'll see what I mean. And this investor goes through and just says, hey, I'm looking for any off-market deals. And they go and they reach out to, 15 different real estate agents. And whichever real estate agent goes and finds them the best off-market deal is the agent that the investor will use. So same thing with the open listing. This one's just reverse and it's for the buyer instead. So guys, I was talking about fiduciary responsibility a little bit ago, and this is what this means. It means that you're going to put the client or the principal's interest ahead of your own. You will, and what this looks like is this: if you're showing someone a house and then you show them a second house, and even though the second house you would actually make more commission, if house number one actually makes more sense for your buyer, that's the one that you're going to help them win. Even though house number two you're going to make more money, you have to put your client's interest ahead of your own. That's fiduciary responsibility. And when we start talking about this fiduciary responsibility and we start talking about agency, I talked about that AC cold. So we owe them accounting, care, confidentiality, disclosure, loyalty, and obedience. And
Charles,
yes.
sorry to interrupt. I have a quick question that reminded me of a question that I saw on the exam.
Yeah.
I don't know if I got it right or wrong. So the example was there's the whole fiduciary thing, and the seller's selling their home, the buyer's ready to buy it, and I guess there was a problem with like a leaking roof, just something was wrong with the home, and it asks, should you still advise the customer or just do fiduciary duty, with your client, which is the seller, and don't let them know anything that's wrong with the house?
Great question. So we actually owe the customer disclosure of material facts. So if we're representing the seller, the buyer would be treated by us as a customer, and we must disclose material facts, and that would be one of them. So that is where we actually would have to tell the buying side that there is an issue with the roof. Great question.
Okay, perfect. Because I was so confused. I'm like, wait, left or right? Like,
Yes.
Yeah, okay, thank you.
Perfect. You're welcome. So, guys, with that fiduciary responsibility, accounting means we just have to know where their money is, right? Like, if we're giving out money, whether it's earnest money check or whatever that looks like we have to know where it is at all times. Care, right? We have to execute reasonable care not to get our clients hurt. Confidentiality, we're not going to give up any information when it comes to our client that is going to put them in a position to where they're not going to win. Disclosure, right? Any material facts that we know, we have to disclose about the other party. So if I'm representing the buyer and I know that the roof leaks, I have to let my buyer know that the roof leaks. Now, if I represent the seller and I find out that the buyer just lost their job and they're not going to be able to buy the house, I have to notify my seller. So we actually have to go through and disclose anything that we know. Loyalty, right? We have to be loyal and we have to do what is in their best interest. And then obedience. Whatever they ask us to do, as long as it is legal, we have to do it as far as the transaction goes. So those are the AC cold that you're going to have to know. And this is the thing. I don't think that you have to remember all of those, but you're going to get a question on the exam that's going to say which of these is not a piece of the fiduciary responsibilities that you owe as a client. And when you're going through, it's going to have a different letter. Like it's going to be something crazy. Like it's going to say like economics, right? While accounting, yes, economics is not one of them. So just be on the lookout for the AC cold piece as far as the letters hitting. So one of the questions that we just got a second ago was around a relationship between an agent and a customer, right? And clients and principals are different than customers. And as we're going through, there's two different ways that you can get into a relationship or have a responsibility towards a customer. And like I said, one of those is you represent the seller on 123 Main Street, and someone walks in off the street. You have a fiduciary relationship with the seller, and the buyer that walks in, you owe them three different things because they're a customer. Fair and honest dealings, right? You're not going to lie to them. You're not going to give them any misinformation. You owe them reasonable care, which means this, like you're going to, I'm air quoting this, but you're going to help them as long as it doesn't put your seller in a disadvantage, right? Like you're going to use your skills like, hey, here's a contract that you need to sign kind of thing, so that your skills, you knowing what needs to happen next, you're gonna provide it to them. They might say, hey, what would you recommend here? And you're gonna say, actually, I recommend that you call a CPA or a lawyer because I represent the seller, right? Because we don't owe them any fiduciary responsibilities. We don't have an agency agreement, which means that we cannot offer them any advice. And then we have to disclosure of material facts. So if the roof is leaking and it's a bright sunny day and that buyer, that customer walks in and they say, hey, what's going on with the house? Anything I should know about? Well, you know that the roof leaks, you must disclose. There's another way that you can have a relationship with a customer or treat someone as a customer. If you're have the buyer in this case, and it could be vice versa, but let's say you have the buyer and you're under contract on a house. The seller, even though they're represented, is your customer. You treat the seller as a customer in this case. So you owe that seller, who's represented by another agent, fair and honest dealings, reasonable care, and disclosure of material facts. So that is the two different ways, and the ways of the test facilitators are going to try to trip you up is that they actually might be talking about the other party, and the other party to the contract is your customer. And remember, the parties to the contract are the buyer and seller. So there's two different things, right? When I was talking about this disclosure material facts, I think of latent and material. And they're called defects. And a latent defect is truly something that wouldn't be found during a normal inspection. Like I said, the roof leaking, if it's a bright sunny day, no one is going to know that the roof leaks if it's not raining outside, right? So it's a bright sunny day, no one knows that the roof leaks, so that would be a latent defect. It's hidden. Or maybe it's behind a wall, right? There's drywall, but there's a crack in the foundation. No one would see that. So we have to disclose that information if it's actually known by us. The other one would be a material fact, right? That's like there is a crack in the wall that they could actually see it. Or maybe there's a hinge that squeaks, right? That is something that is actually seen. The bigger one that as we're going through here would be the latent one. The latent one they don't know of that we know of, we must